Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
Welcome back into the Outlaw Lawyers. Josh Whitaker and Joe Hamer, managing partners, Whitaker and Hamer Law Firm. The power behind the program is the firm. In studio, Cassandra Nicholas and Taylor Scruggs-Smith, also attorneys at Whitaker and Hamer. We're talking all kinds of legalese. I'm Morgan Patrick, consumer advocate. Want to remind you that Whitaker and Hamer, they are almost everywhere. They have offices in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, Gastonia, and now in Morehead City. They are practicing attorneys here in North Carolina. If you have a situation you are facing, you can always call the firm and get some answers to those questions. 800-659-1186. That's 800-659-1186. And email your questions to the show. We'll answer them on future programs. Questions at theoutlawlawyer.com. And there is a great website to visit. That's theoutlawlawyer.com. Josh?
All right, so we've got a federal case out of Texas. So this is federal. We always talk about where we're at because every state has state courts. They have federal courts. There's different levels, district, appeals, Supreme Court. So we always want to know where we're at and what we're talking about. So we have a case that comes out of Texas Federal District Court that's kind of changing the way we think about gun laws. And so this analysis here, we have someone who was under the terminology used in the case, and again, every state's different, was felony indictment, right? So we've got someone who had a felony indictment, meaning they were awaiting a trial or some sort of resolution on felony charges of some sort, and they went to go buy some guns, that's always a good time to do it when you're under felony indictment, to go buy some guns. And they were denied, right? The background check said, hey, this guy's under federal indictment. He can't buy guns. He didn't like this, and he sued in federal court, saying that was a violation of his Second Amendment right to own guns. And so we talked about it a lot this past Supreme Court session. One of the cases we discussed was New York State Rifle and Pistol Association versus Bruin. This was a case where folks in New York, there was a very restrictive concealed carry permit law, and these folks basically said it amounted to not being able to get a concealed carry permit unless you had some extenuating circumstances, and it wasn't legal under the Second Amendment. And the Supreme Court agreed with them. They said, you're right, this is too restrictive. They struck down the New York concealed carry permit law and kind of said the Second Amendment is not a second-class right. It's just as important as the First Amendment, and kind of started this new thinking of how to treat the right and restrictions to the right to own a firearm under the Second Amendment. And so here our district court judge agreed with that, kind of saying all law-abiding Americans have a right to carry a handgun outside the home for self-defense. That was the finding in the Bruin case that we talked about. Did you guys see this case? It was just this week.
I think I just saw it yesterday, but
I don't know much about it before reading for this, but it's definitely interesting and it'll have a lot of impact. Even a lot of places are implementing the red flag laws where people's right to purchase and have guns can be restricted before they've committed any kind of crime when there are risk factors involved. Whereas this one, they've already been charged with a federal crime, a federal felony, right. And they're saying that not allowing them to buy guns is prior restraint. And prior restraint is normally talked about in the First Amendment context, where someone, usually a newspaper, is trying to be prevented from releasing something, releasing news, saying something they shouldn't. But they can't be prevented before they do it. They can only be sued or charged, depending on the context, after it's done. So using the prior restraint language in context with guns, you just have to wait for them to use the gun to do something about it.
I thought this was just interesting. No matter what side of the line you fall down, I don't think, and I think I was talking about this with Josh during the break, I don't think we've actually seen a case in the modern era where we've actually questioned whether or not somebody that's been charged, about to go before a jury to figure out if they're guilty and potentially sentenced, has the right to a gun. Because most of the time, you go to court for a criminal charge, you have a bail hearing potentially. And if there's a bail hearing, one of the conditions typically is like you won't have weapons. So,
and judges typically have a pretty wide berth of what they can put as restrictions. They can put a lot of different restrictions on if we're letting you out of jail, you can't, like, they can have you restricted to your home.
Not leave the state, making sure you're not a flight risk. So it's interesting just to see how this is coming up, because I don't think we've ever really questioned this before. And I think it will have, however this gets decided, will have impacts in the criminal field in a pretty big way.
So our guy here, Jose Quiroz of West Texas. So what he was facing state charges of burglary, and then I guess he also jumped bail. This is what he's charged with. This is all allegedly burgled someone and jumped bail. But he was trying to buy a semi-automatic handgun, and he was denied at the time of the sale because the background check showed he was under indictment. So he has federal charges now of making a false statement during a firearm purchase and illegal receipt of a firearm by a person under indictment. So the whole incident left him with additional federal criminal charges. A jury convicted him on both accounts, and he asked the court to reconsider considering the Bruin ruling. And so this district court judge agreed with him and say there's nothing constitutional about preventing someone who's been charged with a felony from owning a firearm. Now, I'm guessing a judge could have added that to his
bail.
I guess jumping bail. So he paid bail, was released, and never came back to court. That's what jumping bail. That's what I take jumping bail to mean, is you're processed, you're charged, you go before a judge, the judge allows you to be released, and then you don't come back after you post a bond, you post bail.
And just so our listeners know, indictments are typically only done in federal big felony cases, but that means a DA had to go before a grand jury and present the evidence first to get indictment, and then they are arrested, taken before a judge, have a bail hearing. The judge can say, bail's at $100,000, but if you get out, you can't leave the state, you can't do this, you can't do that. And those are kind of standard restrictions put on somebody if they decide to bail out until the trial.
And so I thought this was interesting. You kind of have a quote from the judge in this district court case. So the judge Count said the Supreme Court's ruling had changed the legal landscape on firearm restrictions. He found prohibiting this Quiroz from receiving the gun while under indictment amounted to a form of prior restraint that violated the Second Amendment. And so then the comeback from the other side, so the defending party here is the state of Texas, and they said there are no illusions about this case's real world consequences. Certainly valid public policy and safety concerns exist. So you got these two competing interests here, and I can kind of sympathize with both sides, right? But at some point we have to draw a line. Where is it fair to draw a line? What does the Second Amendment really guarantee us?
I thought it was interesting that they're now potentially looking at how this could affect people owning a gun that's under 21.
Well, and there was a separate ruling in Texas where a federal judge struck down a state law, it's Texas state law, barring adults under 21. It's been at 21 for a long time, hasn't it?
Long time.
Yeah. Since I was young, I don't know.
Tell us the history, Josh.
We used to ride our
with your handguns when you were like 12 years old.
I saw a stat. I don't have it in front of me. And I'm probably embellishing it because I'm just remembering it. But I saw the amount of guns sold in the U.S. for like the past 10 years or whatever. They had this number of total guns sold, and then they divided it by the total population of the U.S., and it came out to where it'd be enough guns for everybody to have like 7.4 guns. I don't have
woman, child.
I was like, I don't have quite that many guns, so somebody out there's probably got like 10 or 12 to account for the 7.4 limit I have not reached. But I tell you what, if I want someone hearing gun cases, if you're pro Second Amendment, you want gun rulings coming out of Texas. That's where you want.
Yeah, seems to be the case. It is. I was trying to look up stats specifically on the number of federal felony indictments because it is, I believe, fewer than state felony indictments. throughout the country, just because states control a lot more of the criminal law at the ground level in the country.
Right.
So this won't immediately, at least, affect anyone charged with a state-based felony, just folks with federal felonies. But it'll be interesting to see how that plays out.
Yeah, I didn't think that ruling was a big ruling, and I didn't think we'd see changes from it this fast, but apparently, federal judges see that as the new precedent, and they're kind of interpreting that to be much more lenient than what was in place before. So it's definitely changing kind of the way we look at gun laws in the U.S.
The Outlaw Lawyers, we will be back with more legalese, more discussion. Josh Whitaker and Joe Hamer are the hosts, managing partners at Whitaker and Hamer Law Firm. We have, again, Cassandra Nicholas and Taylor Scruggs-Smith, also attorneys at Whitaker and Hamer, in studio with us today. Offices located for Whitaker and Hamer: Raleigh, Garner, Clayton, Goldsboro, Fuquay, Varina, Gastonia, and Morehead City. And just a reminder, again, Josh and Joe, managing partners and also practicing attorneys here in the great state of North Carolina. If you've got a legal situation you're facing and you've got questions, call this number, 800-659-1186. That's 800-659-1186. That'll get you in touch with Whitaker and Hamer. You can leave your contact information, briefly what the call's about, and someone with Whitaker and Hamer, an attorney, will be in touch with you. You can also send your questions to the program. We'll answer them on future programs. Questions at theoutlawlawyer.com. When we come back, we'll talk more about the special master discussion. That's coming up next.